Hello, everyone. Welcome to our review of the NYDFS 500's new Second Amendment. So, a quick agenda for today's meeting. We're going to go over introductions of the WithSecure team, and then give you a quick summary of the NYDFS 500, the key changes, what hasn't changed, i.e. what you don't have to worry about for now, give you our analysis of these key changes, and leave some room at the end for some quick Q&A. All right, so for introductions, John, why don't you start?
Thanks, Miguel. Hi, everyone. I'm John Gerald. I'm a security risk management consultant here at WithSecure. My responsibilities include doing cyber maturity assessments against various industry frameworks like ISO 27000, NIST CSF, and also regulatory requirements like NYDFS. I also do cloud configuration reviews, web application pen testing, threat modeling, and secure design reviews, and all the other SRM services that WithSecure offers. Prior to joining WithSecure, I worked in two large financial institutions in cybersecurity, and also was involved in regulatory compliance, including the NYDFS security regulation.
Hello, everybody. My name is Richard Sauls. I'm a security and risk management consultant at WithSecure. I work with John and Miguel very closely. I do threat modeling, build reviews, design reviews, tabletops, crisis management exercises. You name it, I do it. A little bit of NetSec as well. And in my spare time, I serve as an expert witness to the courts in the US and New England. And prior to being at WithSecure, I was an entrepreneur working for myself in the security realm for about 15 years, serving smaller, medium-sized businesses.
Thanks, Richard. So I'm Miguel Gutierrez, a security and risk management consultant. My work here at WithSecure deals mainly with security architecture design reviews, as well as some cloud config reviews, really just about anything I can tag along with these two on. Before WithSecure, I did work at another financial institution here in New York City. Working primarily as a security architect, as well as helping our cybersecurity program get in line with some of the very many regulations that apply to financial institutions.
So just a reminder, if you have any questions, please submit them using the questions tab. We will be answering them towards the end of the webinar.
So just a quick summary of NYDFS and the amendment. New York State Department of Financial Services is responsible for overseeing financial institutions operating in New York. In 2017, they enacted a cybersecurity regulation to help address the growing threat of cyber attacks against the financial sector. And then last year in November, they released an amendment to that to address the new changes in the threat landscape and some of the deficiencies they'd seen that led to successful attacks. And that amendment will be the topic we cover today. So we're going to go through each of the sections. There's maybe a lot of content, but we won't cover all of it, just calling out the key points. So the first section, number one, is the definitions. The changes here are mainly just adding new concepts that were introduced in the updates and in the amendment. The one definition we would call your attention to here is the risk assessment. So we'll cover this more later in that section, but this the definition of risk assessment was significantly expanded. So you will want to make sure that you understand that.
Yep, so the next section we have here is 500.2, the cybersecurity program. Here there's only one major change here, which is now NYDFS requires Class A companies, which are your larger institutions, to conduct an independent audit of the cybersecurity program. So one curious thing about this requirement is that there's been some back and forth between the covered entities and NYDFS. So the initial regulation, since we've been following this for a while, prescribes that the auditor had to be external, right? So after a couple of rounds of comments, we saw that a lot of the institutions said, hey, we're large companies and we have the expertise to do this internally. So after a couple of those rounds of comments, NYDFS budged, listened to the covered entities, and now the requirement says it can be either internal or external. However, you do have to prove that these auditors have the expertise to actually conduct these audits.
So we're talking about cybersecurity policy in section 3. Updates to the policy requirements include, DFS has added retention to the original policy requirements. They've added end-of-life management. They've included remote access and notifications. Two things that we want to call out to this is that managing end-of-life technical debt can be a huge challenge to firms. It can be very costly and time-consuming. And we also wanted to mention that vulnerability management is important, and the policy needs to be clear in terms of timely remediation. So you have to be able to justify what your timely remediation means, how long it takes, and why it might take that long.
Cybersecurity governance, so a couple changes here. One is relatively minor, that they're adding an additional section to the annual report to the board that covers remediating material inadequacies. And then the big change here relates to adding specific responsibilities for the board of directors. And these include overseeing cybersecurity risk management, having sufficient knowledge of cybersecurity in order to exercise governance effectively, ensuring that the cybersecurity program is implemented and maintained, and also ensuring that the program is allocated sufficient resources to be able to be successful. Yep.
Up next, we have vulnerability management. I think one of the biggest points here that we really want to emphasize is, apart from any automated scanning tools that you might have in your state, NYDFS really wanted to hone in on manual reviews of any systems that aren't covered by that. So think any legacy systems, appliances, just anything that doesn't fall under that umbrella, right? And so that manual reviews are always going to be a tricky process. And so again, as part of the requirement, they want you to define that process, let them know how you're going to do this. So it's not something that any tool is going to capture. And on top of that, timely vulnerability remediation. So think about, do you have any SLAs for these vulnerabilities that you do find? And think about that backlog of tickets. What are you doing with that? Is there a plan for that? You can't just, again, have everything on paper and not do any of it. So NYDFS might ask you for proof for what you're doing. Yeah.
So in section 0.6, the audit trail, we've noticed there have been no changes. It's the same as the last amendment.
So on the identity and access management section, there's been significant change. The original version only mentioned you need to manage access and review it on a periodic basis, a couple sentences. Here they've added paragraphs of new prescriptive requirements, and these are really around limiting access to non-public information, specific handling of reducing the number and use of privileged accounts, some more specifics around frequency of access recertification, and so on. Two big areas here also is that they're requiring that Class A companies, those larger organizations, implement a privileged access monitoring solution, and also a solution to automatically block weak passwords. So for these two, for privileged access management solution, a lot of organizations may already have this, but you'll want to assess how effective that solution is. Specifically, have you onboarded all your privileged accounts to that solution? Are the accounts being rotated? Do they have owners? So on and so forth, because all of that will be now subject to examination. And then with regard to the blocking of weak passwords, this is simple on Windows, but you should think about legacy systems that may not support this, and what type of solutions you can develop to address this requirement there.
And again, with the application security section, we noticed there were no changes. Under risk assessment, however, they have greatly expanded the definition of what risk assessment means. It is much more comprehensive, and it aligns much more directly with NIST, which I personally think is a great move on their part. You should pay careful attention to your risk assessment. It is going to be the basis by which many other things are judged or assessed by DFS. So you're going to have to be able to justify how you've created and done your risk assessment. And again, with section 10, cybersecurity personnel and intelligence, we've noticed there are no changes for this particular round.
For third-party service providers, there what used to be an exception, which they've removed. This looked to us to be an edge case that maybe not many entities are qualifying for this exemption or using it, but if you do, you should be aware that it has been removed and you'll need to implement your own third-party risk management policy.
Yeah. So 500.12 multi-factor authentication. This is a big one. So NYDFS came out and said it. They want MFA for any individual accessing any system within your estate. With one small exception, these are 500.19a. These are like very small financial organizations. So I'm thinking it might apply to most of our audience here. For such a highly impactful requirement, we did reach out to NYDFS for some clarification about how to best implement, how to best satisfy this requirement. And they were pretty responsive and gave us some clear answers. So I think first off, if you have federated SSO at the, we'll call it the entry point, say a workstation, you don't necessarily need MFA for subsequent access to federated systems, which is good news, I think, for us. And another point we wanted to highlight is this also includes MFA. This requirement also includes MFA for any workstations. That includes either remote or on-prem. So any employee coming into the office, logging into the workstation is going to need MFA to get in.
Asset management and data retention requirements. So most of you probably already maintain an asset inventory. However, what we've come to see is that they're expanding the requirements for this yet again. And what that means ultimately is that we would recommend a centralized single source of truth. That way, when DFS comes to discuss your asset inventory, an individual is the custodian for that. Now, that of course means that perhaps John is responsible for a certain section and reports up to that custodian, and Miguel is responsible for another section, reports up to that custodian. And it's very important, of course, to be able to kind of track that lineage. We highly recommend auto discovery for this, and obviously we understand that not everything can be auto discovered, but it will take a bulk of the effort away from you, or reduce the effort necessary. And again, like many other things with DFS, we've seen that they're looking for accountability on this. So that again, that centralized single point of truth is really what you're going to be looking for with your asset inventory. Obviously, again, we understand most organizations are already doing asset inventory, but we also understand that it's a very difficult thing to do well and accurately. So they're looking to, perhaps you might say, hold one's feet to the fire a little bit more closely in terms of this. And it's completely understandable about how this ties into the rest of these requirements.
Yeah, so for monitoring and training, we've seen NYDFS take a more prescriptive approach, like we have in many slides before. Specifically calling out implementing an EDR and a SIEM solution, and even more generally, making sure that you're filtering web and email traffic. As part of our analysis, I think one thing I want to highlight here is that DFS isn't looking for you to fulfill a checkbox or set it and forget it, right? I think it's highlighted here. They want you to review the effectiveness of these controls. So make sure you have something to show DFS that whatever you've set up is actually working and detecting things. You don't want to take the easy route. Yep. And so 500.15, we've got encryption requirements. This is another big one. So first off, they've removed the option to have any compensating controls, right? And broadly, encryption has to meet industry standards. So here we have to think about what's hard to implement. So legacy systems is a big one, and there's quite a bar raiser coming in the near future. With NIST publishing that they believe that advances in quantum computing technology might render RSA ineffective by about 2030. That's coming up soon. And they've already gone through, I think, about 4 rounds of review for standardized, they call it post-quantum encryption algorithms. And so this 4th round, I think, just closed for comments November 2023. So expect these standards to be coming out soon.
Incident response and business continuity management. So there are new requirements to develop and maintain your BC, business continuity, and DR, disaster recovery plans. DFS wants to know that you have the ability to restore data from backups and that you've tested these plans annually at the very least. And that includes incident response plans as well. And quite frankly, I'm very happy about this because I love providing tabletops and crisis management exercises to our clients. And so I'm very excited about the uptick that this will potentially offer in these types of exercises. I feel that clients get an awful lot out of these types of exercises. It's, you know, one thing to write up a plan and shove it in a drawer. It's another one to write up the plan and then test it amongst all of the potential stakeholders of that. And so I'm very excited to see that they are looking to make sure that these things are tested regularly and ensuring that the plans are thorough.
And I think this is the last requirement that we have on here, and this is notices to superintendent. Again, NYDFS has gone a little more specific with their requirements, including notices notifying them of any cybersecurity incidents and payments to ransomware actors. I think one important thing I want to highlight now is that notices of compliance have to be signed off by the CEO, and they do give you an option to attest non-compliance, but then you have to provide a timeline and a roadmap for compliance, and you really don't want to say you didn't do it a second time. So it's really important to meet these deadlines that you set for yourself.
So let's talk about exemptions. We kind of touched upon that earlier. Very small organizations with employees of 20 or less. So you can see here on the slide, it's changed from organizations of 10 to 20. Revenue of 5 million, it's been raised to 7.5 million, and they raised the assets from 10 million to 15 million. So if you feel that you might qualify for these, it's obviously worth checking into. And I think what we're seeing here is DFS understanding that inflation has occurred, that the size of businesses being a small business has slightly changed from when they originally set down this amendment. And so I think what they're providing is a little more flexibility for bootstrap organizations.
With regard to enforcement, again, they're raising the bar here. So they defined what constitutes a violation, and this is saying that failure to prevent unauthorized access to non-public information is a violation, and then also materially failing to comply with any section for a 24-hour period would also constitute a violation. So this just signals that the DFS is likely to be, you know, more prone to issuing penalties going forward. They also included a new section, which is interesting, about what are their factors for assessing the level of penalties. I would recommend reviewing this section to understand, you know, their thinking around this. We sort of listed out some themes here. So cooperation and good faith versus being reckless. If you've got prior violations or systemic issues that weren't fixed, looking at just the severity and impact of the violation, the size of the organization and business volume, and if there were penalties that were imposed by any other regulatory agency. So there's a whole list of these. This is kind of trying to summarize that, but it's worth going through and understanding what those factors are.
So while we're talking about enforcement, I'd kind of like to bring up that what we've noticed is that DFS seems to be going from a reactive to a proactive stance. In the past, what we've seen is the majority of violations that they've noted and penalties that they've provided typically are reactive to an attack or to an incident that occurred. And now we're noticing that they are actually proactively policing these types of issues. And John, maybe you can speak to about like the numbers that we've seen in terms of the number of reactive versus proactive fines that they've levied?
Sure, yeah, so like Richard said, we see this as a change in the landscape. So between when they first enacted the regulation in 2017 to 2023, only one of the fines, the enforcement actions related to deficiencies that were discovered in an exam. All the others, there were probably 9 others that related to a security incident that occurred, and that was what resulted in the enforcement action and the penalty. Since 2023, 4 out of the 5 penalties that have been imposed are related to failures that they found during an exam. So this really raises the bar that previously you could expect to be fairly safe as long as you don't have a security incident, but going forward, organizations are likely to get penalties just for non-compliance with the regulation. So that's something we think is important to bear in mind.
And so we're going to come to the questions section. Before we do, I just wanted to let you all know that there will be a copy of the slides available after the webinar for anybody who's interested. Field one of the questions that we have, and John and I can tackle it perhaps.
Sure. All right, so let's see what we've got here. The first question we've got here is, who had input on this new amendment, and did cybersecurity professionals push for updates in this law?
Sure. Yeah, let me take that one. So yes, organizations did have, the DFS published the draft amendment and then opened it up for public comments. And there was a period where people could provide feedback. They actually received about 150 comments, and they made changes based on 32 of those comments. I know this because I did a review of their assessment of the public comments, which was a 90-page document. So DFS definitely, took into consideration feedback from the public. They didn't specifically identify who submitted the comments, but the majority seemed to have been from financial institutions. There were some from academia as well. And the question asked, did cybersecurity professionals push for updates to the law? WithSecure did not submit any comments on the draft. We feel that's a matter that's between DFS and the covered entities. We shouldn't get involved. It didn't appear that many of the comments were coming from security organizations, security firms, as far as we could tell. And the majority of the comments related to sort of lowering the bar. The one exception that stood out to me is that the requirement for MFA on any system for any individual came out of one of the comments. So someone suggested that the MFA requirement wasn't strong enough and suggested any system by any individual, and New York DFS made that change. I thought that was a good suggestion. So, but overall, what we saw is, they did largely did not make changes for many of the comments, but definitely took this into consideration. Miguel mentioned earlier for the external audit, there was pushback around, well, you're just trying to sell for the big, auditing organizations, and we can handle that internally, and they did make that change. There was also a requirement around doing risk assessments by an external organization every 3 years, and they took that out as well. So they did listen and did make changes based on the public comments that were submitted.
The next question we have here is to elaborate on the upcoming compliance timelines for the various amendment items. So I think the first, I wouldn't call it a deadline, but I think this past April was a deadline to submit your attestation of compliance or non-compliance for 2023's requirements. Kind of starts off the timeline for all of the changes to occur. So I think this spring was the first few set of requirements, which is the updated risk assessments, I believe security training as well. And these phases are, I think, every spring and fall. So I think this November is going to be a new set of, I think these are updated policies and documentation. Same with this coming May 2025. And it all culminates with the MFA, the updated MFA guidelines being enforced or required in November 1st of 2025. So they're giving you, since this was published, I think it's about
2 years.
2 years. Yeah, 2 years to implement this in total. Let's see. Oh, okay. The next question we have here is.
I'll take this one. What is an example of a risk assessment that would meet the new regulations? Includes reputation, individuals, assets, etc. This is a good question, how to go about doing risk assessment. The New York DFS, the definition that, as Richard mentioned, the definition of risk assessment aligns with NIST, and NIST provides several different documents or guidelines around doing risk assessments. I think they're 800-30, 37, and 39 all deal with doing risk assessments. Some of that may get overly complex and into the weeds for particular organizations, but the overall guidance that provided by NIST is clear. There's other organizations as well, like ISO provides another document around how to go about risk assessments. That one you would have to pay for. NIST is open source, public. But it's essentially the common approach to risk assessment. Identify your risks, do your assessment in terms of likelihood and impact, and then evaluate what mitigating controls you have in place and the effectiveness, so that you're able to calculate your inherent risk and your residual risk to understand how effectively your program is mitigating those risks. I suspect that given that they changed that risk assessment definition and made it much more prescriptive, that they may not have liked what they were seeing in some of the exams in terms of consistency or level of detail. So I would certainly recommend, spending time on your risk assessment. And then also, like Richard mentioned, is the risk assessment drives a lot of the requirements. So, what the requirement means is going to be up to the institution based on the risk assessment, but like Richard mentioned, that needs to be defensible. So you complete your risk assessment and then you implement the requirement according to how you've assessed that risk.
We have time for one more question.
Okay, so let's see, we've got here small, let's see.
So DFS seems to be going from a reactive to proactive stance. How many entities have we seen fined as a result of that?
Oh,
and John, I think you were just sharing those numbers with us this morning.
That kind of goes back to the previous question that you asked. Yeah, so I think there were 16 enforcement actions, and 5 of those were related to deficiencies on exam. The other 11 were related to a security incident. But as I mentioned earlier, that trend has shifted. So until 2023, virtually all the enforcement actions were related to a security incident. Since 2023, 4 of the 5 have been related to issues discovered during an exam.
So we're seeing a real change in the wind in that sense. Well, it is 12:28. Maybe we can take one more quick question.
So key challenges and recommendations for payments and remittances fintechs. I don't believe there's any specific requirements for payment remittances fintechs. There are exemptions that are related to insurance brokers, but other than that, the regulation doesn't really specify based on the type of the organization, whether it's a mortgage lender or a banking institution or other. The way it is split out is based on size. So like Richard mentioned, there's exemptions for smaller organizations with less than 20 employees or less than 7 million in revenue and so on. And then there's the new designation of Class A companies, which are these larger organizations. So those are really where the regulation is focused on particular types of organizations based on size.
I think you could also consider your risk assessment different as a payment and remittance financial organization, because those organizations tend to have less money sitting around. They're moving money rather than holding on to it.
Yeah.
And so when you're doing your risk assessment, if you are one of those organizations, you can take that into account. And as we discussed, the risk assessment feeds into a lot of the rest of this.
Right. Yeah. So that's a good point. Is the a really good point around risk assessments is that assessment should reflect the sort of nature of your organization. And like Richard mentioned, for remittance providers, they're not having assets permanently on the books in the way that a bank would. So that may affect the way you assess your risk, and that would just need to be, defensible if that wasn't in fact the way the risk was assessed to be lower based on the nature of the money movement, that you would want to include that in your risk assessment, justify it, and it would be appropriate.
Yeah.
Well, thank you for tuning in and attending. This is the third of our DFS webinars, and we're really excited to be presenting this information to you all. I'm sure we'll have others as information comes out further and things change. But if you have any questions, certainly feel free to contact us directly. Our information is available on the website. And as mentioned previously, there will be a copy of these slides available for download if you want to tune in to LinkedIn or potentially other sources. Thank you again for attending, and have a great afternoon or evening.
Thanks, everyone.
Thank you.